Yeah.
I'm ready. Shall we start?
Yes, sir.
Yeah, sure.
Yeah. Thank you. Good afternoon, esteemed guests, respected speaker, and participants. It is my pleasure to welcome all of you to the important seminar on search and survey assessments in new regime under the Income Tax Act. As we gather here today, we are about to delve into some of the most critical aspects of tax enforcement, compliance, and the legal mechanisms in place to combat to evasion and ensure a fair and just tax system. This seminar aims to provide a comprehensive understanding of these operations, covering various important aspects, including legal provisions and powers, practical application, judicial interpretation, recent developments, and changes in the law. Our distinguished speaker, who bring a wealth of knowledge and experience, will help us navigate the complexities of these provisions and provide insights on the best practice for both tax professionals and individuals. I encourage everyone here today to actively participate in discussions, raise queries, and share your experience, as it will enrich our collective understanding of this subject. Once again, thank you for joining us today, and I hope you find this seminar insightful and enriching. Thank you. Thank you very much.
Hello, Bhaskar ji.
Samir Jani, sir. Your introductory remarks, sir.
At the outset, I would thank a vibrant zone, South Zone, for organizing this web meeting on assessments and a new regime of under search and survey. And the faculty, being very young, would be innovative with the new provisions and ideas. Well, at AIFTP, knowledge imparting, education being the one of the E's of the three E stated in the ethics or in the logo. It's an happy moment for me to welcome all the participants and say big thank you for the reason that you are enabling us to deliver at the goal of AIFTP. I don't know, but if anybody who is not a member of AIFTP and is present over here, I would request him or her to become the member of AIFTP and cherish the benefits of being a member of AIFTP. On the topic, the speaker would have prepared herself very well. I would just like to bring to her notice that section 153, which deals with the assessment of in case of search and otherwise, subsection 1 of section 153 limits to 21 months from the end of the assessment year in which the income was first assessable. Now, the provisos to subsection 1 deal with various statutory provisions on various dates like 2018, 19, 20, 21, and last 22. What I would like her to enlighten is that in such cases, if a case is befitting to the facts, then it's better to argue on the facts. But if the facts are weak, then one can go into the technical issues whereby which the time limit, the limitation aspect would come into picture. So what would be the provisions applicable for a search which has undertaken in July 23 or June 23, post April 23, But the reassessment notices or the notices under 148 are being issued, say for 17, 18, 18, 19, 19, 20, whether it would be relevant date or the relevant year which would be concerned with the limitation, or it would be post 22 fled. We have all the delegates waiting to hear you, madam.
Yes, thank you.
Put in your best
Yes, sir.
and keep updating yourself and rather innovating yourself and be a part of AIFTP always.
Yes, sir.
I thank the chairman, the joint secretary, the Mr. Ganeshan, who is an active member from our South Zone. All the deputy chairman will now take over as the chairman for South Zone. I thank all participants for giving support to the South Zone web meet. Thank you very much. Mr. Bhaskar, over.
Thank you, Samir Jani, sir. Now, let me introduce the speaker. She is a second generation lawyer. She is the daughter of Ratan Samuel, sir. I don't know whether Samir Jani, sir, knows. Ratan Samuel, sir's daughter. She is a practicing advocate under the name Ratan Samuel and Associates.
I didn't know otherwise I would have begun with that.
So she is regularly practicing before the Bombay High Court and various tribunals extensively on direct taxes. She has a wide experience in handling tax disputes for well over 12 years. We are eager to hear you on the new topic from the fifth generation lawyer. Thank you.
Thank you so much, sir.
Yeah.
May I comment? Am I audible? May I comment, sir?
Yes, I think you can.
Okay. The topic given to me is scope of assessment under income tax post search and seizure and survey. And this topic to start with is typically a land of jungle, and the jungle is widespread everywhere, and the action of this search and seizure which takes place under section 132, and it is basically the provision of search and seizure, and the action of 132 is digging the unearthed hidden truth. So the jungle is vast. The topic is also really very vast. So we start with it. And my today's topic would be a brief introductions about 132, the rights and basic aspects of person who is searched, the importance of incriminating material, the new regime, block assessment schemes, and various judgments which have come from various courts and Honorable Supreme Court. The introduction of Section 132, the amendments, the pre-amendment and post-amendments of Finance Act, which took place in 2021, then again in 2024, the block assessment scheme with effect from 1st September 2024, and the relevant judgments to the topic. So the introduction to search and seizure provision. Search and seizure provision in the income tax are crucial in addressing the undisclosed income. The Section 132 of the Act targets individuals suspected of evading the tax payment. It is based on a hidden and undisclosed income of property, and to bring it to assessment. The main objectives is curbing of evasion of tax, unearthing the hidden and undisclosed income of property, bringing undisclosed income. Am I audible, sir?
Yes, now you're.
There was some setting issue. So the secreted evidences or anything which is not declared or covered by the SSC and found by the department has the meaning of uncover the hidden or unearthing the hidden income, which is secreted. In India, the provision of search and seizure plays an important role in curbing the menace of undisclosed income. Section 132 of the Act is directed against the person who are believed to be evaded the tax of the income and property. The object of Section 132 is to prevent evasion of tax, that is to unearth the hidden and undisclosed income of property and bring it to the assessment. This the this search and the rights of the search and of the person searched. The proceedings are governed under 132 and the rights there, and there are few rights of the person. The statement recorded under 134. During the course of search proceeding, the statements are to be given without any coercion, pressure, or duress. The statement given during search is not a test of memory. However, the assessee can ask time to correlate any document or entries and thereafter reply to queries of the with the help of assistant if required. Moreover, the cash or jewelry, if seized, the quantification is to be correctly notified. In case of discrepancies, it needs to be brought to the notice of the officer. So whenever the department or the people who enters with a search warrant, there are few rights for the person who is being searched or searched. So the statements which are recorded basically under 132(4) are to be given without any coercion, pressure, or duress. At times, we have seen that there is a lot, the search proceeding is going for two days, 3 days, continuously for 4 days, and then the statements are recorded. The statements are recorded on the fourth day, and it's usually after 9 p.m. or 3 a.m. in the morning. So at that point of time, there are possibilities. There can be pressure on the person on the person who is being assessed. So it should always be, in case there is any kind of such thing which it's under pressure or duress, the statement should be given without any pressure. In case there is pressure or anything built up, it should be brought to the notice of the higher authorities. Secondly, it is not a test of memory. So if anything, any statement has been given by a person who is searched, so in case he is not able to correlate or he is not the authoritative on that very transaction or any other document, he can definitely say that I am not aware about this at the present moment. Please give me some time, or the person who is authoritative to this transaction or this document, I will revert back after consulting him. He duly has right about it, and he can tell those authorities.
Madam,
That-
1 minute, 1 minute. Can I start sharing the PPT, madam? Or you will do it?
What, sir? Yes, sir.
PPT is not
P-
visible.
PPT is not visible.
Yeah.
So just a minute.
Can I ask Ravi to share it?
Yes, no problem, sir.
Ravi, you can share, Ravi.
Am I audible, sir?
Yes, you are audible.
So if Ravi sir will be
Which slide should I start?
Yes, sir, that is what I will not be able to know the slide, which is, so slide number 6. Sir, I had shared the slide. I think if he does it, then I will not be able to change the slide. Just a moment.
If you can share it, no issue.
Yes, I will do it again. Now, is it visible?
Yes.
So,
You can go ahead.
so the person who is being searched has the rights while giving the statements that I will correlate the document or the transaction or the person who is authoritative to it. Usually the directors of the companies are not in the position to explain the transaction, if any, which because he is not related to it, or the transaction has been taken place by the authority in the company, the manager or somebody. So he can definitely correlate his, say that he will correlate it with the person and get back to you. But giving a false statement or giving incorrect statement would lead him to a trouble in later course. Secondly, if the involvement is in regards to cash or jewelry, if it is seized during search and seizure, it is mandatory that the quantification of the quantification should be done correctly. Correctly in sense, if the jewelry has been seized, the quantification means after the exemption of the circular, if any, if the measurements, the quantity has to be quantified correctly. And in case of cash also, it has to be quantified correctly. Secondly, if gold, bullion, jewelry or other valuable articles which has been declared in the wealth tax or ITR, that cannot be seized. And in case if there is any seizure of assets of cash, it under the provision of 132B, there can be adjustment or a release of seized assets can be given. Now coming to this judgment, wherein in case there is a procedure laid down under section 132B for release of seized materials during search. So there is a procedure laid down. So after the seizure takes place, an application has to be given to the assessing officer within 30 days, 30 or 60 days from the date of the seizure. Usually what happens is the investigating team is different and the assessing team is different. So the investigating team might submit his seizure materials to the concerned AO after a period of time. But the provision under 132B, wherein you have to make an application to the assessing officer, the adjudicating officer, within a span of 60 days, that this is the material and the seized materials needs to be released on this ground, and there should be a proper application made to him. And in case there is a delay, there is a procedure for the assessing officer himself to release, in case if he finds and the speaking finding order will be passed, and if he does not release it within a specific time laid down by the provisions, that is 120 days or 180 as the case may be, after the application is received, then the department is ought to have pass an order with interest of 18%, which is due to the assessee. This is the one of the judgment of Honorable Bombay High Court, where I came across, where the order had traveled up to the High Court and then travel up to the tribunal, and the order was in favor of the assessee. However, the seized cash was not released. On a writ to Honorable Bombay High Court, the cash was not released even after the principal CIT's order was there to release the seized cash. Hence, assessee was liable for the assessee had to the department had to compensate in view of this judgment, and interest was payable on the cash which was seized during 19, I think it was a long period. I've not written the period, but it was for a longer period. The order was passed in 2014, and from till on in the year 19, the assessee had filed it before Honorable High Court. Now this Deepak Kumar Agarwal, it's an Allahabad High Court judgment wherein there is a procedure where if in case the assets have been seized, what is the procedure and how to release it and everything. Elaborate finding has been given by this High Court, wherein the statutory provision and the statutory duty of the officer as well as the assessee has been given, and how to release the assets and the procedure has to be given, and it has to be in between the reasonable time. Now coming to this topic, which is types of incriminating materials. So the main topic under search and seizure proceeding and the assessments to be completed are on basis of the incriminating materials found. What is incriminating material? Is basically any evidence found outside except from the books of accounts, or there are various forms. I have just mentioned few forms where I have come across that these can be a type of incriminating materials. And this would lead to reduction of tax liability of the assessee. So usually the assessing officers rely upon the statement given on oath, the assets if found, suppression of sales, bogus purchase, noting on loose papers, difference in the stock, difference in cash, explanation of seized jewelry, unsecured loan, gifts received by relative, cash deposited, penny stock transaction, materials found on third party place, and WhatsApp and Telegram chats and email. This is one of where the recently many judgments have been passed on basis of this incriminating material known as WhatsApp chats and Telegram chats or any other form of electronic records or emails. So I have come across few judgments wherein the WhatsApp and Telegram chats has been used as an electronic record by the department. So recording of statement and retraction. So recording of statements takes place under section 132(4) and it is not a test of the who is searched. The test that 2020 or 2019, and he's not able to say that what this transaction relates. So he can definitely take time and say that this transaction will be correlated and given back. However, few statements which are taken under pressure or under caution or at 3 a.m. or after 4 days or by seizing different premises and everything, there is always the person who is giving the statement has his own right to retract the same statement. So Article 14 of the Constitution, Article 19(1)(g) of the Constitution, and Article 265 all plays an important role while recording a statement as well as while retracting a statement. So these statements are given under 132(4). No doubt, when a person is being searched, his business has been hampered because many of his documents, laptops are taken. He has a right to do business free trade under Article 19 of 1(g). So he can definitely retract those statements if those statements are given under pressure. However, there is one judgment where there's one judgment passed by Honorable Supreme Court wherein they have laid down few angles wherein how a retraction can take place. A statement which is retracted later on after a periodicity, what is the evidential value of the statement? So today, if somewhere in November the statement has been recorded by the authorities, it should be that as soon as possible the statement should be retracted if it is required. And the procedure is, if the law laid down in this judgment is retraction of statement to be made as soon as possible, and the statement has some evidential value under 132(4) and cannot be discarded in a cryptic manner. In a cryptic manner, it means that if the assessing officer is relying on the statement of 132(4) and only on basis of that assessments has been passed and few correlations have been made by the assessing officer, the statements has evidential value. And if the statement is recorded under duress, pressure or caution, the retraction has to be filed within a reasonable time or the assessee or to have file a complaint before the superior authority and file an affidavit with convincing evidences that the recording was done at this time. I mean, like the search was hampering my business and I wanted to close the search, and that is why I have given those statements. They do not have any evidence or corroborated evidence. So the retraction has to take place, and this has to be within the reasonable time. In this case, the assessee had retracted the statement after 296 days. Hence, the Honorable Supreme Court has dismissed the SLP filed by the assessee and has confirmed the judgment of Honorable Supreme Court. So retraction, the statements given under oath under 132(4) and the retraction plays an important role under this. Now coming to the main issue, which is the current hot issue that the WhatsApp chats, the Telegram chats, the app chats, or the emails which are found as can be treated as evidence and used against the assessee. So these are electronic records. So during the search proceeding, any WhatsApp screenshot, Telegram chats, or email will be treated subject to the fulfillment of the Indian Evidence Act. So the Indian Evidence Act, under the Indian Evidence Act, they have brought a provision, and there was a provision, but they have added a few conditions which wherein the admissibility of the electronic documents and record will be treated as documents, and this chats or the emails or any screenshots of any of the apps which has been used can be treated as secondary evidence of electronic records, such as if any Excel sheet is found or any workbook is found and a screenshot has been taken, the conversations, the WhatsApp communications, these records, if seized during the search proceeding, the conditions of Evidence Act 1872 has to be fulfilled. And there is some condition, there are 4 conditions which are laid down, and any evidence used by the authorities in regards to this will be treated as documents, and these are treated as electronic records which are defined under the term documents. There was a recent judgment in 2021 where a writ was filed in regards to this. I've just mentioned it in Vitterville Minerals. It was a Madurai High Court judgment wherein evidence was only on basis of WhatsApp chat and Excel sheets, and they did not imply to the provisions of 65B of the Evidence Act, and hence cross-examinations of statements and employee of the search was not given. So the matter has been remanded back with the direction that this has to be followed, and 65B has to be taken into 65B has to be taken into consideration. Now, there has been a tremendous changes in the provisions of search and seizure, and they are thereafter the assessments. So this is a short bifurcation. The bifurcation is that any search which took place from the period 31st March 2003 to 31st March 2000, 31st May 2003 to 31st March 2021 are governed under the provisions of 153A and 153C. So any search which got conducted before 1st April 2021 will be governed under the provisions of 153A, and the assessments and the proceedings will take place like 6 years from the end of the assessment year, the broken period where the assessment, the 1st April, until the date of the last authorization, and assessment has to be completed within 21 months from the end of the last authorization. Last authorization in the search cases means the last date on which the Panchnama has been completed or the statements have been recorded. So that the term last authorization plays a vital role whenever there is a search case. Now coming to search taking place on or after 1st April 2021 up to 31st August 2024. So there was an amendment in the year 2021 where this scheme of search and seizure proceedings was replaced, and the provision was introduced as per reassessment proceedings, and all the transactions and all the search and seizure proceedings were to be completed as per the provisions of 147 with 151, and the search which took place after 1st April 2021, and the assessment to be completed as per the procedure laid down. So in that year, 3 years prior to the end of the year, or 10 years, now 5 years, if the demand, if the assessing officer feels that it is above 50 lakh rupees. So as the case may be, these transactions are prior to these provisions will be governed on or before 31st August 2024. Any search which takes place, it will be bifurcated into two provisions. So this landmark judgment of Delhi High Court has been known by everybody, because the Honorable Supreme Court in Abhisar Bildwell has also confirmed the ratio descended in this case, and how 153A has to be formed, the assessments has to be completed, and how this judgment has been a landmark judgment till date. This Commissioner of Income Tax versus Kabul Chawla has been followed, and in 2024, this has been affirmed by Honorable Supreme Court in the judgment of Abhisar Bildwell. So these are these are the seven ratios which have been laid down, that once a search under 132(2) takes place, the assessing officer mandatory has to issue a notice under 153A, and the 6 years preceding to it, he has to issue notices, and all the pending assessments at the date of search will abate. The total income will have be computed by the AO on a fresh exercise. In a normal case, in the AO will exercise normal assessment powers in respect of 6 years in which in the search takes place, and the AO has the power to assess and reassess the total income of mentioned 6 years in separate assessment orders for each 6 years. In other words, there will be only one assessment order in respect of each assessment year, in which both disclosed and undisclosed would be brought to tax together. And the fourth point, although section 153A does not say that the addition should be strictly made on basis of evidence found in search or in course of search or post-search material, or information available with the AO can be treated as evidence found. In case if the evidence other than what is found during the search, but in the course of proceeding, if he's found some evidence, that can be added by the assessing officer, but it cannot be arbitrary or without any relevance. In case of incriminating material, the completed assessments can be reiterated and abated assessments or reassessments can be made. The word assess in section 153A is relatable to abated proceeding and those pending on the date of search, and the word reassess to be completed in assessment proceeding. In case the assessments are completed, then a reassessment proceedings can take place. In so far of pending assessments are concerned, the jurisdiction to make original and assessment under 153A merges into one. Only one assessment order will be passed. Completed assessments can be inferred by the AO while making the assessment under 153A only on basis of some incriminating material unearthed during the course of search or requisition of documents or undisclosed or property discovered. So in case there is a completed assessment, the only criteria to issue notices under 153A would be on basis of the incriminating materials. Now, the topic of special procedure for assessment of search cases under Chapter 14B of Finance Act 2024. So before beginning with this, so many of my participants today, I mean, everybody senior to me are revisiting the old provision again in the 2024. This provision was right from 1995. Then again, there was a change in 2003 when introduction of 153A took place. But prior to that, this chapter was already there in the act, which was deleted in the year 2023. So many of the participants will be revisiting the old provisions, but now we say it under the new regime. So the new regime says that the special provision of assessment of search cases under Chapter 14B of Finance Act 2024, and they have been brought under the block assessment scheme. So the block assessment scheme is a procedure of assessing undisclosed income discovered during the search or requisition. Introduced first in 1995, it is allowed for assessing over a period of 10 years, later revised to 6 years. The scheme was replaced in 2003 by sections 153A and 153B, and further integrated with the reassessment provision in 2021. Supra, in few slides above that, I had made a bifurcation that if your search has been taking place before 21, it will be governed under the 153 and 148 proceeding. The Finance Act Finance Act number 2, Act 2024 reintroduces the block scheme applicable to searches from September 1 to 2024, assessing of total income for 6 block period plus the period up to the last authorization of the search. This scheme streamlines the process, ensuring consolidated and efficient assessments in the search cases. So the image here is like a jigsaw puzzle, because again, we'll be revisiting the same provision in the different manner. So that is why I have put this jigsaw puzzle. So the block assessment scheme here is divided into 8 sections. So the first section is the definition. I'll just run through it. There are 2 definitions. One is the block period and second is the undisclosed income. So the block period. So this plays a vital role because any search which took place after 1st September 2024 from this year, the total income will be assessed and the block period will be assessed. The block period will consist of 6 years previous to the search and also the period from where it from the 1st April till the last authorization. So in case the search took place on 1st October, the period prior 1st October 2024, then the assessments of preceding 6 financial years, assessment years, and a period from 1st April till 1st October will be governed under the new block scheme. Any pending assessment or reassessment during block period shall abate and be considered in the block assessment. If the block assessment has been annulled, if the block, there's a mistake, the block is in case if any assessment has been annulled, the term block is wrongly mentioned here. If the assessment is annulled on appeal, the abated assessment will be revived. The block period for any other person involved in search will be same as for the person of for the searched. The block period of other person which has other than the person searched, the same provisions will be governed. Now coming to the definition of undisclosed income, it's almost a paragraph which has been mentioned in the act. I have brought down to 2 points, which is any money, bullion, jewelry, or other items or things or expenditure or income based on an entry in the books of account or other documents or transaction representing income or property not disclosed for the income tax purpose. This is one limb. The second limb, which is it also covers incorrect expense, exemption, deduction, or allowance for the block period. This is exactly the provision what we had in 153A and prior to that in chapter 14B during 1995. But the only term which has been added in this limb is it also covers incorrect exemption. The term exemption has been newly added here other than expense, exemption, deduction, or all allowance for the block period. The other material, that is any money, bullion, jewelry, or other valuable items or expenditure or income based on entry is the same as the previous thing. But the provision also covers incorrect expense, exemptions, deductions, or allowances for the block period. Now coming to section 158A, which speaks about assessment of total income. So how the total income will be computed under assessment of the total in this provision. The total income excluding the undisclosed income discovered during the search of the previous year was initiated be passed independently under the normal provisions of the Act. All pending assessments will abate and completed assessments will be treated as unabated. The income for the block period will include aggregate of returned income, assessed income, A, returned income, B, assessed income, C, declared income determined for the current year, and fourth, undisclosed income determined by the assessing officer. Assessed losses brought forward from assessment year within the block period will be ignored for the block assessment and may be considered in subsequent regular assessment. So in case this there was loss carry forward for the block period, the first period, the loss will not be allowed. It can be considered after the block assessments. If any the losses in the subsequent regular assessments, you can claim it. The total income of the block period shall be reduced by the return income, assessed income, income determined for the current year, and remaining income will be taxed under section 130 at the rate of 60%. The computation of the income is the total income of the assessee in the return furnished under section 158 BC for the block will be as per this. I've drawn a chart. I've made a chart under this that it's the same thing as per the previous slide, but in a what is computation of income, that it will add total income assessed in the hands of the assessee before the date of initiation of the block period will be considered as any scrutiny if taken place, any best judgment assessment, any reassessment, any assessment under 153A, that will be, and any income which is based on the total books of accounts and other documents maintained up to date till the date of requisition or the search. And as per the, and last is the undisclosed income by the AO based on the evidence or information found during search and requisition. And this will be the total income less whatever has been disclosed, and the and total undisclosed income will be the income for the block period and will be taxed at the rate of 60%. This is in regards to loss, the loss, if any, which has been brought forward from the periods before the block period, and unobserved depreciation will not be allowed. It can be carried forwarded after the block assessment scheme. Procedure for block assessment. In case there is a search, I'll just take a moment. I'll just have a water. Procedure for block assessment. So if the person who is being searched, the procedure laid down is that a notice under section 158 BC will be issued, which requires assessee to file a return within the period of 60 days. So there is a time limit given. After this notice is issued under 158 BC, the time limit, the maximum time limit the AO can give to the assessee is 60 days. All pending assessments will abate, and notice to file shall be attached under section 158 BCA. The above return of income, the assessee shall include the total income, including the undisclosed income, and this will be a single return in respect of the entire block period. Above return filed will be considered as return filed under section 139, and notice under 143(2) of the Act will be issued accordingly. No revision of the return filed under 158 BC will be allowed. It is not possible to revise any aspect in the return which has been filed against the notice of 158 BC. Assessing officer shall, on basis of the above return of income filed by the assessee, determine the total income, including the undisclosed income for the block period, as per the manner laid down in 158 BB, the computation which I just showed, and the other assessment or reassessment provision under the Act, and pass an assessment order determining the tax payable by the assessee. Now coming to this provision, section 158 BD, undisclosed income of any other person. This is other than the person who is being searched. There might be details which are, there are some evidences or any materials which has been found by a person search. So there can be assessments under section 158 BD, which was previously 153C. This is 158 BD. The term here is where the assessing officer is satisfied that any undisclosed income belongs to or pertains to a person other than the person with respect to whom search has been made under section 132, or whose books of accounts, documents, or any assets were requisitioned under section 132A, then the money, bullion, jewelry, or other valuable articles or assets, or expenditure of books of account, other documents, any contained therein, seized, requisitioned, shall be handed over to the assessing officer having jurisdiction over the person, that the assessing officer shall proceed under section 158 BC against other such person, and a provision of this chapter shall be applied accordingly. The term satisfied plays an important role in this provision. So basically, the explanation to this provision is, if in case any evidences or any materials which has been gathered by the investigating officer in regards to some other person who is not being searched, the documents, the material will be given to the assessing officer of the person who is being searched. After scrutiny, if he feels that this documents belongs to some third person, the evidences will be given to that officer. However, the assessing officer of the person who is other than search has to have his own satisfaction that this document or this material or this item belongs to this assessee, and hence a notice under 158 BC will be issued, and all the provisions under this chapter should be followed. The Supreme Court in the previous when the before the amendment of 2003, there was this judgment of Tapan Kumar Datta. It is basically the reintroduction of the same section. So this judgment duly applies in the case of Tapan Kumar Datta. The very objective of this section 158 BD is to given the jurisdiction to the assessing officer to proceed against any other person other than the person against whom search warrant is issued. Although section 158 BD does not speak about recording of reasons as postulated in 148, since proceedings under 158 BD may have monetary implication, such satisfaction must reveal mental and dispassionate though process of assessing officer in arriving at the conclusion, and must reasons should be basis of initiating under section 158 BD. There should be the satisfaction of the assessing officer issuing the notice. The term satisfaction plays an important role here. And in the provision of 148, there are recording of reasons. So Honorable Supreme Court have distinguished this case on a greater length. Now coming to this judgment of Ajit Kumar versus Commissioner versus Ajit Kumar. And this is one of the landmark judgment passed in the year 2018 by Honorable Supreme Court. The facts of this case was that the assessee was searched and at the same time, on the same date, the builder of the assessee was also searched. There was a survey which took place, and during the course of search proceeding, the assessee has already declared few incomes and had also some details were available, and he had declared that income in the books in the return which was filed against the notice issued. However, during the course of survey, it was found that the assessee, Mr. A, who has been searched, a cash was given to the builder, Mr. E, and that was approximately 95 lakhs, which was not disclosed in the return file in pursuant to the notice issued under search proceedings. So the assessing officer and the assessing officer made an addition on basis of the survey which took place on the related person, that is the other person, that is the builder, and the AO had passed an order making addition of 95 lakhs. The commissioner appeal also confirmed the view of the AO. However, the tribunal had deleted the addition, and the High Court has dismissed the appeal of the department. However, the Supreme Court has laid down this principle and has given a ratio that there is no cardinal principle of law that in order to add income of any income in the block assessment, evidence of such must be found in the course of search under section 132 of the Act, or in any proceeding simultaneously conducted in the premises of the assessee or person connected with the assessee and having transaction or dealings with such assessee. In the present case, in response to the notice under 158 BC of the Act, the assessee filed admitting the cost of investment and disclosing the details of transaction between assessee and the builder in the AY 2001 and 2. However, he had not disclosed the payment of 95 lakhs made to the builder in cash. The method of calculating undisclosed income of the block period is provided under Section 158 BB of the Act. It can be calculated only on basis of the evidence found as a result of search or acquisition of books of account or other documents and such other materials or information which is available with the assessing officer and relatable to this evidence. Any other materials or information as available with the assessing officer and relatable to the search evidence. No departure from this provision is allowed. Otherwise, it may cause prejudice to the assessee. However, 158BH of the Act, it's a similar provision. 158BH of the Act makes all other provisions of the Act applicable to assessments made under Chapter 14B, except otherwise provided in this chapter. The power of survey has been provided under Section 153A of the Act. Therefore, any material evidence found in survey has been simultaneously made at the premises of the connected person can be utilized can be utilized by making the block assessment in respect of an assessee under section 158 BB read with 158 BH of the Act. This would fall under the words any such other materials or information which is available by the with the assessing officer and relatable to such evidence occurring in section 158 BB of the Act. The assessing officer was justified in taking the adverse material collected or found during the survey or any other method while making a block assessment. So this is one of the landmark judgment in case where a person has been searched and any other person, there is a survey, the material, if gathered at the time of survey, if any, the incriminating materials can be used against the assessee. The time limit to complete block assessments under this chapter is 12 months from the end of the last authorization which took place under section 132 or 132A was executed. The period of completion of block assessment in case referred into 115 BD shall be 12 months from the end of the month in which the notice 158 BC has been issued. In case if there is a reference of 92 under section 192CA, a further period of 12 months will be extended. In computing the period of limitation, a period not exceeding 180 days from the date of search shall be excluded to hand over the seized material. In case there is any seizure of any materials which has been relied upon, that has to be handed over to the assessing officer within 180 days from the date of search. So this is relevant that the date of search, not from the last authorization. In all the other provisions, it has been mentioned from the last authorization, but the handing over of documents has to be from the date of search. There is a limit. Computing of period of limitation excludes any injunction, any stay proceedings, reference is made to valuation officer, principal commissioner in income tax, or any pending AAR is pending. There is a list of exemptions that limitation period will exclude those period, and then again it will continue. Under 158 BF, certain interest and penalties will not be levied, or interest will not be levied. There will be no interest under section 234A or 234C, or penalty under 270A of the Act shall be levied, or interest in regards to the blocked undisclosed income assessed or reassessed for the block period. The tax levied is under section 113, where 60% will be levied on the undisclosed income. So after the computation, the undisclosed income will be levied at 60%, and no interest under 234A, A, B, C, or penalty under 270A will be levied. This is now in case there are few interest or penalty which will be levied and which will be governed under 158 BFA. So if in case the assessee fails to file a return under section 158 BC, assessee will be liable to pay interest at the rate of 1.5% of the month or the part of the month starting from the end of the period specified in the notice till the expiry till the extension of this order has been made. An assessing officer or the commissioner appeals in the course may direct the assessee to pay by way of penalty a sum of 50% of the tax leviable on the undisclosed income. So the penalty can be levied in this, but under this provision of 158 BFA, but only assessing officer or the commissioner of appeals can direct to pay that. And no penalty under section 271 AD, AAD, 271D, 271DA, or 271E shall be levied if the assessee has furnished the return, paid the tax as per the return, or offers to adjust the money or the asset which has been seized. Evidence of paid is been furnished along with return, and appeal is not filed against the assessment on the part of the income which is shown in the return. Now, the authority competent to make assessment on the block period, all orders on the block period shall be passed by assessee not below the rank of deputy commissioner or assistant commissioner, deputy director of an or an assistant director. Approval of passing shall be taken from additional commissioner or additional director or the joint commissioner or the joint director. This is important because usually what happen, the provisions of 148, 147 to 151 are governed, and there are criteria where the principal commissioner, the principal chief commissioner can give the approval. Whereas under the block assessment scheme, only the additional commissioner, additional director, joint commissioner or joint director can only give approval for the completion of the assessment. Now, I have categorized a few judgments wherein the practical issue, this was the end of the block assessment scheme, which has been reintroduced, and it has been effective from 1st September 2024. This was the last provision of section 158 BG, where the authority has been who can pass an assessment order. Now coming to, I have categorized two issues which are mainly faced by the assessees. One is loose papers found during the search, then the statements which are recorded, and few judgments which are important during the search proceeding, as well as during the course of assessment proceedings. And this is a practical issues where in and day out we are facing by our clients. So any loose papers found during the search, practical issues faced Practical issues faced during assessment in search and seizure cases are additions on account of loose papers, statement given during search, retraction of statement, diaries, and notings. Assessment can be completed on basis of incriminating materials, and incriminating materials cannot be associated to loose documents, papers, or loose diaries unless and until it is corroborated effectively with independent evidences. And in many judgments, the view has been taken by several tribunal, high courts, and Supreme Court. So basically, whether loose papers forms books of accounts has been clarified, not clarified till today. There have been assessment orders which are being passed only on basis of the loose papers. So these are few judgments which of Honorable Supreme Court. The first one, CBI versus VC Shukla, though this judgment is on the criminal proceeding, but this is the Jane Hawala diary cases, which is an landmark judgment, wherein they said that notebooks or the file containing loose papers do not form parts of books of account. And this judgment has been followed by many tribunals and High Court in the tax matters, and hence these loose papers are not admissible as under Section 34 of the Evidence Act. The next judgment of Supreme Court, that the settlement commissioner found that the scrutiny of the entries of loose papers and computer prints, hard disk, pen drives have revealed that the transaction noted on documents were not genuine and have no evidentiary value, and these details in loose papers do not comply with the requirement of Indian Evidence Act and not admissible under as an evidence. This judgment of Pune IIT Manoj Chajir versus ACIT, the assessing officer had not caused any further inquiry with the seller of the plots. The entries in the diaries were not corroborated with any independent evidence. The assessing officer has also not attempted to verify whether these transactions were entered in the books of account or not. Therefore, the diaries cannot be considered as books of accounts maintained by the assessee regularly for the purpose of the business. Similarly, these documents cannot be termed as speaking documents for the reason that it does not reveal any taxable event, any person on whom tax can be levied, as well as the year of taxability, etc. Therefore, these documents can be termed as dumb documents, which cannot form the basis for making addition in the assessment. These are few more judgments in regards to that in regards to loose papers. So if any loose papers has been found during the course of search proceeding, can be treated as evidence only if they have subsequently the assessing officer has taken initiative and corroborated few other evidences and related to the loose papers. Secondly, in case there are a lot of entries in which year the taxability has to take place, it cannot be the diary has been found in the year 2024, so the transactions will be added into 24. There should be specific signatures or the signatures, the year of taxability has to take place. So everything will play a vital role in regards to the loose papers which are found during the course of investigations. Now coming to statements recorded under section 132(4) and retraction. So during the course of investigation, as mentioned earlier, that there are circumstances where the statement is recorded at 3 a.m. in the morning, or the search has been taking place since 4 days, and the assessee is pressurized to give some statement. So retraction can take place, and the statement given under section 132(4) has evidential value, but only similarly with the loose papers, the assessing officer should corroborate few evidences after the statement has been recorded. And in case there is a retraction, the retraction, as the SLP in Roshanlal Sancheti has been dismissed, the Rajasthan High Court has laid down certain principles how a retraction should take place, which is also there supra in my submission. So this case is of Vinod Solanki. This is an old judgment, and this has also been followed till date, that evidence brought on record by way of confession which stood retracted must substantially corroborated by other independent and cogent evidence which would lend equivocal assurance to the court, and that may seek to rely thereupon. We are not oblivious of some decisions of this course wherein reliance has been placed for supporting such contention, but we must also know that in some cases retracted confession has been used as piece of corroborated evidence and not as evidence on basis of which alone a judgment, conviction and statement has been recorded. In the second judgment of Pune ITAT, raising a for the legislature to have been employed the word may in the language 132(4) has, which delineates that the statement made by the assessee may or may not be used as evidence in the assessment proceeding. The nitty-gritty of the matter is that though a statement under 134 carries immense weight and works as an evidence, but the same is not conclusive insofar as the legal assertion or legal consequences of factual assertion as the stated in the statements are concerned. This is the third judgment of Jharkhand High Court. Now, this judgment is of, I am skipping that judgment because it is regards to the same thing, that the evidence, the entire assessment was completed on basis of the confession, and however, on the proceedings before the various authorities, there was no corroboration of the evidence, and therefore the additions were deleted in the Jharkhand High Court. Now coming to this judgment, ACIT versus JKD Pearl India Developers. It's a Jaipur bench ITAT judgment wherein all the other judgments of Supreme Court and the various high courts has been considered, and in this judgment, there were two things. One was the additions were made on basis of dumb documents, what we say is a loose papers and diaries, and there was no corroborated evidences after that. And secondly, on basis of the confession. So this judgment is it's a more than 100-page judgment, and they have briefly I've made a brief about it from this judgment. I'm reading from the second point. From the totality of the facts and circumstances of the case as narrated and discussed, we are of considered view that mere admission is not conclusive as the truth of the matter. It is only a piece of evidence. The weight to be attached to which must depend on the circumstances which is made. It can be shown to be erroneous or untrue. Therefore, addition made merely or slowly on the basis of confession without any corroborated evidence was not substantial in law, and moreover, the said confession made by the assessee was subsequently retracted. And since the addition was not supported by the cogent, convincing independent documentary evidence, therefore the same was correctly found to be not sustainable by the learned CIT. As per the assessee, the papers at page 1 to 4 of the annexure 2 are rough and dumb papers because these papers do not have signature of the assessee directors. Even the originator writer of these papers are not found, and these papers are undated. On the analysis of page so and so of the annexure of 2, we also find that allegation levied by the assessee are correct, and apart from these papers do not contain any name of the buyer, and the AO was in the position to correlate these papers with regular books of accounts. As per the assessee, certain flats shown as sold in this papers were actually sold subsequently to the search, And in this respect, they have also submitted documents with the AO. It is an admitted fact the AO himself in the assessment order at page so and so has categorically admitted that these papers do not have any date, but he presumed that this belongs to the assessee to the period when it was found and seized. In our view, no liability can be fastened on basis of assumption and presumption, and it is a settled law that presumption, whosoever strong may be, but it cannot be the place of proof, and thus AO had acted more on suspicion, doubt, other than evidence. It is a settled principle that suspicion, however, cannot be take place as evidence. So basically, in this, on the date of search, some documents were found without any signatures, without any year of mentioning or the date of mentioning. So the assessing officer presumed that the addition can be made on the date of the search taking place, and all the additions were made in the year of search itself. So on concluding it, there is a checklist, and the checklist is because on account of amendments from time to time, the search in which so on the date of search is very important, and under which provisions your assessments will take place. Statements and seized statements and seized materials. Second is assessment notices and returns, completion of assessment on evidence found during search, and in any other person, satisfaction of assessing officer. The last point in regards to 150, is in regards to 158 BD, if any other person, and in regards to the above three. So the conclusion is that this is, as I stated earlier, that it is a typical land of jungle where there is no head, there is no end to it. The only thing is that the assessee should be cautious about everything, whatever stated today, and my participants can use it during the action of survey and search with their clients. So I end my presentation for today. Any questions?
Not precisely a question, but I would like to supplement, ma'am, to you
Yes, sir.
that Gujarat High Court, in the case of the Principal Commissioner of Income Tax Central versus Kaushik Nanubai Majithia, it's an order dated 6/3/24.
6th?
3/24.
Yes, sir.
I'll give you the tax appeal number also.
No. I will get it.
It's 20/24, wherein they have held that an unsigned Excel sheet would not constitute as an incriminating document, and any addition, even they went further, saying that the person who was searched, accepting it under before the settlement commissioner and paying the tax, would not make it an incriminating document so far as 153C is concerned.
Yes.
For the purposes of making an addition. Can you share the PPT also? There are some things which I could not find, which was not to my knowledge. You enlightened us.
No, madam, he is asking whether you will be in a position to share the PPT to the participants.
Yes, I can.
Yeah.
I already emailed it to Bhaskaran sir. So
Yeah.
and it's with Ravi also. So Ravi sir can also share it. I can definitely share.
Your
Yes.
permission is required before that.
No. I can share my PPT.
But in all, it was a really pleasant performance,
Thank you, sir.
an informative PPT or in deliberation. Keep it up. Wish you all the best.
Thank you.
Bhaskar sir, I may be permitted to leave.
Thank you, sir. Thank you for staying so long, sir, in spite of your busy schedule. Thank you. Yeah. See you in the next 3 weeks, sir.
Sure. Thank you so much. Welcome again.
Thank you, sir. Sir, any questions from the floor, sir? Speaker is ready to take the questions.
Sir, I've got 3 or 4 chats. Everybody is requesting to share the PPT. So
Yeah.
it can be published or it can be sent. I haven't.
Yeah, I will do it. I will do it.
So, any questions?
Any questions, sir? Okay, we'll close this session. Chairman, sir. Ramana. Chakar Ramana. Okay, on behalf of the AIFTP South Zone, I thank you, madam, for giving this wonderful presentation on a Saturday evening, relaxed. Thank you. This subject, as you say, is a jungle. We need to come out of the jungle to the civilized society. It will take some time. As I said earlier, this started in 1995. It took almost 29 years to revive this provision once again. And all those judgments which have been rendered in the G1, then now it will be useful for G5 also. And the subject is still improving. When in 1995, when the provisions were introduced, we don't know what is WhatsApp, what is Instagram. And even the email also, that was not prevalent. But over a period of time, the technology has developed, the incriminating materials volume has also developed, and the sources are too many. So the subject is a developing subject. Thank you very much once again. Thank you all the participants for a patient hearing. Thank you.
Thank you.
Thank you.